Welcome, everyone, to today's workshop, The 5 Steps You Should Take to Plan for the Future of Your Child with Special Needs. We thank you for being on today. This workshop is being recorded, and all participants will receive a link to the recording within the next few days. My name is Patricia Clay, and I am the Director of Operations and Client Services here at the Law Offices of John K. Hilton. Before we get started, I want to take a minute to make sure you can hear us and see our screen. In the question box, please type the number 1 if you can hear me. Great, it looks like you can hear me. If you cannot see my screen, please type in the number 2 in the question box. Perfect. It looks like everybody can see my screen. Okay, let's get started. With the overload of people on the internet, sometimes screens can freeze up. We appreciate your patience if this happens. There will be a questions and answer period at the end, but John's workshops are interactive, so please feel free to post in the question box at any time, and we'll be sure to answer your posts. And finally, John will be offering a special gift to you, so please stay till the end to hear about this gift. Again, thank you for attending, and without any more delays, I'd like to welcome John Hilton.
Oh, thank you, Patricia. I am just really excited to be here today to talk to you guys about the 5 critical steps you must take to plan for the future care of your child with special needs the right way. As I get started, I'd like to introduce you to my son, Anthony. Anthony is 30 years old, and he has autism among various other disabling diagnoses. So while I talk about Anthony, hopefully you've downloaded your workbook, and if you have not, if you'll look over in the taskbar where it says handouts, there should be a PDF called the 5 Steps Handbook. And if you'll just get there and go ahead and download it now so you can follow along, that would be great. So once you have that in your hand, while I talk about Anthony, go ahead and look at the first page of your workbook and start completing this section titled My Reality. And when you get there, you'll see what kind of information I'm asking you to think about for yourself. So Anthony, you know, he was born right away after he was born. We knew that there was something different about him. We didn't know what. It took quite a few years to actually get an accurate diagnosis, and I'm sure many of you have experienced the same situation. So you know, over time, we began to see what his capabilities and limitations were going to be. And it became very apparent that Anthony was not going to be able to be independent, and he would not be able to live on his own. He would not be able to hold down a full-time job. And so the questions began to really you know, rise in me is what would happen to Anthony if something happened to his mother and me? If we were no longer around to take care of Anthony, where would he end up? And, you know, all I could see was this vision of Anthony and all of his unique personality quirks and all the things that make him so special in an institution where, you know, no one really cared about what made Anthony special. No one cared about the little things in his life that could set him off into, you know, a crying spell or get him stressed out and get him, you know, into a cussing spell. Anthony, you know, I mean, like all of you guys know, our children have very unique characteristics and everyone's different. And so as I began to talk to my family about it, you know, I started getting a lot of advice. Well, you know, do you have, you know, the proper life insurance? And so you need to make sure you got life insurance. Have you set up a savings account? You know, and then several people, oh, you've got to set up a trust. And I'm like, well, I don't even know how to do that. Who do I talk to? Do I go to the bank? Do I go see a lawyer? An accountant? Who sets up a trust for me? Didn't even know. And I was overwhelmed by confusion and was really experiencing that paralysis by analysis. I just had no idea which way to turn. And I really feel like a lot of you can really relate to that. And I'd kind of like to hear from you. So if you can relate to those kind of feelings, I'd ask you just to go ahead and enter the number 1 in the question box. All right, yeah, so, I can see that you guys, you do relate. And so before we move forward, I kind of like to know a little bit about my audience. So I'd like to know who listening has a child with special needs under the age of 18. And if you have a child under the age of 18 with special needs, again, go ahead and enter a number 1 in the question box. If you have a child over 18 with special needs, enter the number 2. All right, excellent. So a little bit of both. We have some people with younger children and some with older. Now I have another question. If you have a child or children under the age of 18 who do not have special needs, who are what we often call neurotypical, go ahead and type in yes in the question box. Okay, yeah, so we have a mix. We have some parents that have younger children who do not have special needs, and we have children over 18 with and under 18 with. So we got the full spectrum here today. So I can imagine that many of you have experienced this same feeling that I had. This is what my journey looked like when I started trying to figure out what to do for Anthony and started actually moving forward with the plan. It was rocky. There were lots of trip hazards. There were lots of curves in the road. I couldn't see what was beyond the next curve. And the future was very nebulous. I had really no idea where this would all end up. But I took the journey, and I was able to create a plan for Anthony that assured me that he would be taken care of not only financially, but he'll be taken care of by the people that I want him to take care of him, and in a way that I want him to be cared for. So what I did is, this had such an impact on me, and I said to myself, you have gone down that path, and nobody else, should have to go down that same path you went through. So I have the ability now to be a guide and straighten that path out, illuminate it, and create, this straight and easy path that I'm able to be a guide for others and help them take the journey. So I want you to be assured that your time today is very well spent. And so in order to kind of help you be that assured, I want you to offer you a gift. If you stay tuned to the end of this workshop, I'm going to give you a link to schedule your complimentary one-on-one meeting with me personally to talk to you and the people you love the most about how you can protect them. And also, I'll have a special gift for anyone who schedules time with me immediately following this workshop, a little extra bonus. And this is important because I only take a very limited number of new clients a month. I've helped many families with their estate plan, and while I have a lot of experience doing this, and you would think I would meet with anyone who wanted to do this important planning with me, the reality is that I actually limit the number of appointment slots like the one I'm offering to you, because I like to take the time to become well acquainted with my clients. I like to give my clients the full amount of time that we need to get their plan exactly right. And I really only want to work with people like yourselves who are taking the time to get educated about these important decisions and the steps that you have to take or really must take to properly plan for your child with special needs. So keep that in mind, and let's dig in. So this is just one of our clients who we helped, who had has a special needs child. And he told us, no, we owe you all the things for helping to ease one of the many big burdens in life. And then here's another, this was just a wonderful woman who also has a child with special needs. And she says, thanks for all you have done for me. And I can't tell you how secure I feel having all in place for my loved ones. And those are the kinds of testimonials that we get from clients that really illustrate that, once this planning is done, there is that real feeling of security and peace, because now you know what would happen and how your child with special needs would be treated and cared for when you're no longer available. And these are just two of many, many. I just pulled these out to illustrate how our clients feel once this planning has been done. Now I'd like to introduce you to my family. This is the reason I do what I do. And you can see in the top left, it's my beautiful wife, Julie. And then, I've got two of my kids are married and have their own children. One of them is engaged. That's the one in the bottom right-hand corner. That's their engagement picture. And then in the bottom left-hand corner, you'll see that picture of Anthony. And really, I got into this because of Anthony, but what I discovered was that this planning affected not only Anthony, but it affects my entire family. And for many, many reasons that I'm not going to take the time to get into here, other than to say one of the things it has done is it has relieved Anthony's brothers from the responsibility of thinking that they might have to figure out how to support Anthony when his mother and I are no longer around to do so. And so they're able to get married and have kids and live their lives without that hanging over them. So as we move through this, I really want to kind of establish some foundational principles that as we start looking at these 5 critical steps that we're going to discuss here in just a few minutes, these principles guide every decision within those 5 critical steps. And so the first one is that you must keep your children out of the hands and homes of strangers. And I don't think I would have anybody disagree with me that have the thought of having your children placed in the home of strangers, in the care of strangers, if something happens to you, if you become incapacitated, seriously injured, or die, the idea of our children ending up in foster care while the courts figure out who's going to take care of them, it terrifies me, and I'm sure it terrifies you as well. The second underlying principle is that unlike our what we call neurotypical children, who we can anticipate graduating from high school at 18, going to college, graduating from college, getting a good job, starting a career, getting married, starting their family, and no longer being reliant and dependent upon us to financially care for them. Most of us who have children with special needs are going to require our care and financial support throughout our child's entire lifetime. And that's much different than the normal family that doesn't have a child with special needs. It used to be some years ago that we didn't have to worry about that. Children with special needs, with Down syndrome and others, they had a very short life expectancy. And it was really, parents kind of prepared themselves that they would outlive their child. But with the advances in medical technology, we're able to provide our children with special needs, great quality of life for many, many years now. And now many of our children are outliving us, and so the question becomes really real for us. How can I be sure that my child with special needs will have the financial support and have the social support that they are getting from me right now that I will no longer be able to provide when I'm no longer here? So then we have the third underlying principle, and I think this is probably one of the really critical and most important of these, because I sit down with families all the time who have limited resources, and they're really worried about how to care for their children and ensure that they're going to be safe and provided for after they're gone, but they're struggling because they really don't have that much available to set aside for their children. And so one of these underlying principles is that you have assets that are so much more valuable than money. And we're going to discuss that. I'm not going to go into that particular principle right now, but it's going to come up later. And I want you to keep that in mind, that this kind of planning is not only for people with large numbers of assets and retirement plans and life insurance and everything that they've already have, who are able to set aside assets for their child. This planning is for everyone. And so, keep that in mind, that you do have other assets that are much more valuable than any kind of money that you may or may not have. So ask yourself these three simple questions as we move forward. Number one, what would happen to your child with special needs if you did not come home at the end of the day, if you did not come home from work? And I'm kind of think about this from a standpoint of if you're a single parent whose child is reliant solely upon you, what would happen? And if you're, a nuclear family and you have a spouse, what would happen to your child if both of you did not come home, say from a late dinner or something like that? What would happen to your child? With that same scenario, what would happen to your other children, your children who do not have special needs? Because this is about them as well. And finally, would your children be provided for financially if you did not make it home? Your child with special needs and your other neurotypical children. So I want to kind of show you the common scenario with this. And this is about what happens in the short term if you don't make it home. And we're going to consider a hypothetical situation here. So you leave your kids with a caregiver and or a babysitter. And maybe you live the babysitter or the caregiver, your cell phone number, maybe your neighbor's phone number. But if something happens to you, you can't answer your cell phone. And if your neighbor does not have a specific legally designated authority to care for your children, then the police, when they arrive to try to figure out what's going on and to see if you have children at risk, they have no choice other than to call in Child Protective Services, because they cannot leave your child in the care of someone who does not have legal authority, and they just can't take that risk. So on a practical level, here's what would happen. Your children end up in the home, in the care of strangers and in the home of a stranger. And I think that kind of addresses that first principle. Never are we going to allow our children to end up in the care of strangers. And I was a paramedic for many, many years, and one day I responded to a rollover incident, and the driver had been killed, and in the back seat was a young, probably young teenage, what they call a tweener girl, and she was blind, and she had some other developmental delays and disorders. And I can still hear her, because she didn't know what was going on, and she was saying, "Mom, are you okay? Mom." She had no clue what was happening. And my heart went out to her because, I had my son, and I just, felt for this girl. But we didn't have any information on the mother to tell us who to call. So we went through her purse. We tried to find information, like who can we call to take care of her child? Well, the police officers on scene ended up having to call CPS because we couldn't find anybody else who had legal authority to take her. And that breaks your heart when you see that. And as a father, the thought of my children being taken into custody by the authorities, especially Anthony, cared for by strangers, even temporarily, even for a couple of hours, a couple of days, it could be as long as a couple of weeks or longer. And them not understanding what's going on, having gone through the trauma of, wondering why, mom and dad haven't come home to get them, that scared me to no end. I just couldn't imagine allowing that to happen. And I know you don't want that to happen either. You wouldn't be here listening to me if you didn't care about your children. So in just a few moments, we're going to talk about the specific steps you can take to avoid that scenario. Now let's talk about what would happen in the long term. So this is the short term. This isn't, the time period immediately after you don't make it home to your children, and before the courts are able to decide who would make a suitable guardian to raise your children. So in the long run, there is a plan. There's already a plan in place, but you're probably not going to like it, because in the end, a judge decides who will take care of your child with special needs. And it will most likely not be the person that you think is the best to do that. And I'm going to just tell you a quick story that would kind of help illustrate why it's so important to designate now who you would want to care for your children in the long term if you're no longer able to do so. So let's assume that there are two people who would want to raise my children if something happened to me. And we're going to call the first one my hypothetical sister and my hypothetical sister-in-law. So my hypothetical sister is 26 years old. She lives in Scottsdale, Arizona. She's not married. She's never had children. She still likes to go out to the bars and clubs and generally has a good time. Now, my hypothetical sister-in-law is 38 years old, owns her own home, has 3 children over the age of 9, has a steady job at a bank, and she lives in Tucson. Now, you be the judge. You've heard the facts about these two women. Who would you choose to raise my children? And I'm going to ask you to go back into the question box. If you think my sister, 26 years old, Scottsdale, not married, no children, still likes to go out and have a good time, is the best choice, and go ahead and put 1 in the question box. If you think my sister-in-law, 38 years old, has a home, children, great job, would be the best choice, then type in the number 2. So, the choice is obvious. Everybody's saying, well, of course, the sister-in-law. She's stable. She's got a stable home. She's already raised children. She would be the right person to raise your children. And, that's an obvious choice, but it's the wrong choice. And, the reason is that the last person in the world I would want raising my kids would be my hypothetical sister-in-law. Not because I don't love her. I do. She's my sister-in-law. But because in my heart, I know she would not parent my children the way I would want. Whereas I know that my hypothetical sister would, despite her circumstances, despite being single, she would raise my children exactly the way I would want them raised. But a court would never be able to judge that. If you look at them on paper, my sister-in-law is the obvious choice. And here's a worst case scenario. My sister and sister-in-law end up getting in a fight about the court's decision. And they're fighting it out in court, and they're, suddenly this relationship is destroyed, and the kids, while they're fighting, end up in foster care while the court's trying to figure it out, because no one has legal authority to have my children in their care. Obviously, that's the worst case scenario, but you know, it happens, and we do see these scenarios play out. So, you know, this scenario is easy to avoid, and we're going to talk about how to do so here in just a few minutes. I want to talk now about probate, and there are a couple of different areas here of interest. So to start off with, if you do not have a will and if you do not have a trust, you have no estate plan that you've created, it does not mean that you don't have an estate plan, because the state of Arizona has already created an estate plan for you. So really what happens is, if you don't want the state's plan for you, then you need to go out and create a will or a trust for yourself that's different from the plan the state has for you. So that's if you die. And the other thing is, if you become incapacitated, then you're still going to end up in the same court, in probate court, except here, instead of the court enacting the state's estate plan for you, the court in the judge is going to appoint someone to make decisions for your children and give someone in your family access to your assets to care for your child. And this is called guardianship. Some of you may have already been through this with your children. Some of you may be considering it, and we'll talk about that here in just a moment as well. So if you become incapacitated or you died and your child is left without you as a parent, then those two things are going to happen. First of all, the state's going to look at all your assets and they're going to distribute them according to the state's plan. Now, the state does not take into consideration that you have a child with special needs. The court does not take into consideration that if your child inherits any assets, that it will disqualify them from their public benefits. The bottom line is, if your child is 18 or over, they get whatever Arizona state law says that they get, despite any kind of other circumstances. If your child is under 18, their share of their inheritance will be set aside, and when they turn 18, they'll get their entire inheritance. So they could easily lose all their public benefits on their 18th birthday. If you become incapacitated, the same thing. Let's say something as simple as having a stroke or being involved in an accident or developing Alzheimer's. The same thing will happen. You're no longer able to care for your child. Someone has to go to court and tell the court that you know, they want to care for your child. And again, this is often a place where families fight because you'll have competing members of the family thinking that they would do a better job raising your children. And often the underlying reason for this is that they also get control of the money. And so, you know, not everybody approaches this from, you know, from a truly charitable and altruistic perspective. So you can see on the slide here that this is the probate process. And we're going to look at this right now from a perspective of death. If you should die, this is what will happen. And this is true whether you have a will or whether you do not have a will. Okay, and that's a misconception that I want to make sure everybody understands. It does not, a will does not keep you out of the probate process. It does not keep you out of court. It does not keep you out of any conflict that may arise through that. Whether you have a will or do not have a will, you go through this same process. And so what you're going to have is, you can see this is a long pipe, and it's a drip system. You know, the water, if you will, is flowing through this system very slowly. And as it goes through, attorney's fees are pulled out of your resources. Your executor's fees for your personal representative are pulled out. Appraisers fees for your assets are going to come out of your assets as well. Your personal representative may have to post a bond. You have to pay your creditors. You have to pay court filing fees. And so all of this will drain your assets and your estate as you're going through this process. So it's an expensive process. It's also, as I just said, very time consuming and slow. We're looking in Arizona, 9 to 12 months is as fast as you can expect it to go. We've had some, that have gone more than 2 years trying to get this through the court system. And for someone, which is going to be your personal representative, they're going to have to do a lot of work during that year or more. They have court appearances. They have to get notices out to all the creditors. They have to pay the creditors. They have to decide, which creditors to pay, which ones not to pay. They have to get appraisers. It's a lot of work for your personal representative. And I talk to people in workshops all the time, and I ask them, how many here have ever been a personal representative? And I always get a couple of hands go up. And I haven't found one yet who has told me, oh yeah, it was no big deal. I happily do it again. Every one of them was like, oh my gosh, I'll never do that again. It was horrible. I don't want to do it. Some of them have told me I'm still in the process of going through probate, for my mother's estate, and it's terrible. So this is something that when you look at it on paper, looks fairly simple. But when you talk to the people who have gone through it, most of them say that it's not something they would like to go through again. Now, the other thing that happens is during this 9 to 12 months or more, while they're going through the court process, your family, your loved ones, your child with special needs, they don't get access to your assets. There's a small stipend or an allowance that the law allows them to have so that they can eat and not be thrown out of the house, but it's not very much. And so not until probate is actually closed or ended and the judge, rubber stamps the final decree, do your loved ones actually get to own your assets. So, that kind of raises the question, would you rather have your creditors getting access to your money and your assets right away, or would you rather have your children, especially your child with special needs, getting access to your assets? So now would be a good time to look in your workbook, and there's a section called My Current Estate Plan. And then there's another section called Probate, and I believe this is on page 3. Go ahead and complete those sections of your workbook. And in the probate section, indicate what part of this probate process that I just explained to you, you would find most concerning. And while you're doing that, we're going to actually take a little bit of moment, and you'll find this in your workbook on page 3, where it says My Assets. We're just going to do a quick calculation, show you how to figure out what your probate estate would be. So this is a typical family that comes to see us, owns their home. Their fair market value of the typical home is around $200,000. And they typically will have, maybe anywhere between $80,000 to $125,000 in equity on their home. They still owe, another $75,000 or $100,000. They'll typically have bank accounts. They may own some stocks or bonds, but they'll have cash and cash equivalents, often around $15,000 total. And then they'll often have personal property. And personal property, we're talking about all your furniture, your vehicles, artwork, everything that you own as part of your daily life that does not have a title, such as your home. And a lot of them will actually be running a small business on the side, and they might be valued at $25,000, $30,000. And so as we're going through this, look at your workbook and kind of put your numbers in there. There's it's not a test; it's just to kind of give you an idea of where you stand. And then most of our clients will end up actually having a small life insurance policy, $100,000. Sometimes much more, sometimes a little less, but they've been able to get a life insurance policy through work or through their parents or through some other means. So if we add this up, everything you see over there in the left column is your probate estate. All of those items have to go through the probate process, the court process. And everything on the right hand, or the life insurance, that actually has a beneficiary designation. And so that does not go through the court process. That goes to your beneficiaries directly and outright, usually within a week or two. But what does it cost to go through probate? Well, in Arizona, you can count on anywhere from around $3,500 to $6,000, just depending on the extent of appraisals and things like that that have to be done. It's going to take, like I said, at least 9 to 12 months, often longer, and it's public. And I think this is something that people don't often realize. The probate process is a public court document, and anyone can go down to the courthouse and find out exactly what you had when you died and who received it. And the reason this is important is because what we know now is that there are so many predators and scammers out there who actually use this information to try to get your children and your beneficiaries of your estate to give up their inheritance. Posing as the IRS, saying, oh, you owe 35% on what you just received as an estate tax, you just send us a check. And a lot of our kids are not mature enough or developed enough to know that this is a scam, and they're scared of the IRS, and they'll write them a check. And so this is one thing about the probate process that I think is really concerning when it comes to having children with special needs, especially if they're higher functioning and semi-independent, and they receive this kind of notification, phone call, or letter from someone pretending to be the IRS or some other scam, that they may fall for it. The big question is, during this time, who will care for your child? While you're going through this probate process, it's 9 to 12 months minimum, who's going to be caring for your child? And we're going to talk about that again here in just a second. Now, here's the other thing, and I talked about this just briefly, but if you have a minor child, when they turn 18, if you've died at 18, they receive your inheritance. And they receive it what I call unprotected, meaning that if they in the future get married and divorced, or if they file bankruptcy, anything like that, the court can actually take a large chunk of their inheritance that you worked hard for and saved for them, and use it to pay off the new ex-spouse, to pay off the creditors in a bankruptcy and things like that. So, and of greater importance even, I think, is you have a child who is dependent on government benefits, and if they turn 18, they're immediately disqualified if they get more than $2,000 in assets. So this is something that, I think I really ask everybody to kind of keep in mind and think about when you're doing your planning. Now, talking about your child receiving assets, there are several ways that can happen. I'm going to quickly go through these. They can get an outright gift from a family member, and this could be the way of cash. Maybe your family member, a grandparent or aunt or uncle has left the gift for your child with special needs in their will. Maybe they have done a beneficiary designation to give your child a car or a house or stock that they've invested in. And we already know how that's going to affect your child. It's going to disqualify them from benefits, and it's probably not going to be enough to make up the difference. The other way your child can get assets is through an ABLE savings account. And I'm sure many of you are familiar with the ABLE accounts, and you probably set some up for your children. We're going to discuss those here in just a moment as well. Another way that you can make sure that your children receive assets is through your will. We just talked about that, what would happen. Go through the probate process, the time, the cost, the energy that it takes, and the fact that it's public. The final way that we're going to discuss is through a supplemental, or what we often call a special needs trust. And we're going to discuss how that works as well. So let's talk about getting a gift from a family member. First of all, your child cannot receive a cash gift of any significance until they're 18 years old. And we know that if that gift results in them having more than $2,000 in cash assets, that child will likely lose their state and federal benefits. This is Anthony. And if Anthony, he had to have really significant facial reconstruction surgery in order to allow him to breathe properly and to swallow without choking. And, if someone had given him a cash gift that caused him to lose his benefits, this would not have happened without a great deal of difficulty from his family trying to pay for it. So let's talk about the ABLE account. I get a lot of questions about the ABLE account. Is it right for my child? And I'm going to say, obviously it depends. But this comes from legislation that was passed at the federal level in 2014. Arizona adopted it in 2016. And it's the Achieving a Better Life Experience Act. And what they say is that if your child was diagnosed before the age of 26 with a disability under the federal definition of disability, then you can open this ABLE account, and that account can receive a total of $15,000 per year in contributions from anybody. It can be from you, it can be from family, it can be from a GoFundMe campaign. It doesn't matter. $15,000 is the maximum amount of money that can be contributed to that ABLE account in any one year. If that ABLE account exceeds $100,000 in total value, then your child that it benefits may lose their public assistance. And so you have to kind of really keep an eye on that. And this makes it, for many people, not a great option because they have family or they have life insurance, they have other things that they want to help their child with that will exceed that $100,000. So the only people that can open an ABLE account are the disabled person themselves, a guardian, parent, or a financial power of attorney. And here's the big kicker. Let's say you have $100,000, you got $95,000 in your ABLE account, and your child dies. The very first creditor that's going to come knocking on your door or on your child's door is Medicaid. And Medicaid is going to say, okay, everything that we spent taking care of your child, we want it back. And that's one of the things about an ABLE account is that it has what's called the Medicaid clawback provision, that anything left in that account when your child dies, Medicaid is the first one to get reimbursed for whatever they've ever spent taking care of your child. So let's talk about, well, okay, I've created a will. And I've left, some assets to my child in the will. Sometimes I hear people say, well, I have a will, but I just inherited my child because I know that if my child gets these assets, he'll be or she will be disqualified from public benefits. So I left everything to my child's sibling, and I've asked them to take care of my child with special needs when I'm no longer here. And we're going to talk about the effect of that. Let's move forward and keep that in mind. So first of all, a will is only effective upon your death. It does not take into consideration any period of time in which you may be incapacitated and unable to be there for your child. And as we've said, if you leave your child more than $2,000, it may disqualify them from receiving state and federal benefits. And it's not protected from creditors and scammers from bankruptcy, from judgments, for lawsuits, things like that. And your will may or may not name a guardian and conservator. And I see many, many wills that I review for clients, and they never thought to name a guardian for their minor children or conservator if they're no longer here. And that's one of the big, holes that we often see in wills that people have gone online to do, or that they've gone to an attorney who doesn't really specialize in this type of planning. So let's go back to that scenario where I said, well, I've just inherited my child with special needs, and I left everything to his sibling, and my sibling has said that they will take care of my child with special needs, after I'm gone. A lot of people do that. That's the best a lot of people know how to do. Here are a couple of issues. The sibling, let's say, receives the entire estate, and let's say that estate is worth, let's just say $100,000. And the sibling says, okay, well, half of that's mine, so I'm gonna put $50,000 over, so I got $50,000 to take care of my brother or sister with special needs. What happens if that sibling should get divorced? Well, Arizona's a community property state. And so the court isn't going to say, well, you got this $100,000. I understand that you set $50,000 aside for your sibling with special needs. They don't look at that. They say, you got $100,000. And under Arizona community property law, half of that is going to belong to your new ex-spouse. And so they can lose it. Let's say that the sibling gets into credit trouble, and just look at what's happened here in the past few months. So many people have lost their jobs and are experiencing a lot of difficulty. So what if that happened to the sibling and they had to file bankruptcy? The court's going to come in and say, oh, well, you got $100,000 sitting over here, and you're like, no, half of that's for my brother or my sister. And they're going to say, I don't see that anywhere. That's your money. We're going to use it to pay your creditors. So when you do that, you actually run the huge risk of your child with special needs not getting the care that they need. And it's a common scenario. A lot of people have tried to get around, the public benefits issue by disinheriting their children and leaving it to their siblings. But in the end, it's just a huge, huge risk. This is something I'm going to bring up over and over as we talk about this. Does your will provide instructions for caring for your child with special needs? And when we first started, I said one of the principles we're going to say is that you have assets much more valuable than money. This is one of those assets. You have the ability to provide instructions for anyone that you selected to take care of your child. You can provide a manual for them if you do your estate planning the correct way. And that is more valuable in my mind, knowing that my child will be cared for the way I want him to be cared for, that I can pass on what his quirks are, and that I can let somebody know that if he's in the bathroom sitting in the tub for 2 hours, that he's chosen to do that because that's how he self-soothes when he gets overstimulated. Those are the kind of things I think are more important to me than leaving, $1 million for my child to be cared for. There are other ways to address those things as well. So the question comes, during this, this thing, who's going to actually care for your child while your will is being processed through the probate court? And how can you be sure your child will be properly cared for? So let's look at why a will is just not enough. So you write your will, you die, your will goes through probate. Remember, we've talked a lot about probate. And finally gets to your child with special needs. And you've made that decision that you don't want to jeopardize your child's public benefits, so you've left it to your child's sibling, and you said, please take care of your sister. Well, here's another scenario that comes up. Besides being able to possibly lose that inheritance to a divorce, to bankruptcy, to a lawsuit, we're all human. And one of the things that we find is that as humans, if we run into financial difficulty, we are able to rationalize that, well, I'm just going to borrow $10,000 from my sister's account. I'll pay it back. And I'd ask the question, how many of you have ever borrowed money from your 401k? And how many of you have ever paid it back? And I'm going to guess that probably none of you have ever paid it back, and maybe one or two. If I'm wrong, throw it up in the question box and let me know, hey, I paid mine back. I borrowed money from my 401k and I paid it back. I'd like to see that, but I'm guessing that most of you did not. So, okay, I've really kind of taken this, this first period of time here, this first almost hour, just to talk to you about all of the possible issues that come up in planning for your child and some of the things that you need to be aware of. So I'm going to take the next 30 minutes and really just kind of go through these 5 critical steps. And these 5 critical steps are going to address everything that I've been talking about up till now. So the very first critical step that you should take is to choose the right guardians for your child. And I'm going to go back. Remember the question about my hypothetical sister-in-law? And I said, the one of them is, in her 30s, has a job, has a house, has a great job at a bank. The other one is in her 20s and single and still likes to go out in Scottsdale and kind of live it up. And both of you said that my sister-in-law would be the best choice. She's the stable one. And so here's the actual reality is that we just don't know, because it's a human judge that's going to make that final decision. And the only thing we can really do is make sure that judge has all the information they need to make the right decision. So here's what we can do. We can put in writing what you already know to be true in your heart, who the people that you believe would be the best people to raise your child if something happens to you. So how do you decide? If you're not sure, let's go through a very quick exercise. And I want you to follow along. We are in step 1 in your workbook. It's called Name Guardians. I believe you'll find that on page 4. So the very first thing you're going to do is create a short list of potential people that you would trust to raise your child the way you would want your child raised. Now, almost everyone starts going to immediate family, my brother, my sister, my nephew, my aunt, and that's, absolutely fine. But I want to expand your mind that besides those immediate family members, you have distant family, you have godparents, you have, college roommates, and even to add to this list, you've got things like neighbors and pastors and priests and things like that that may be willing to step in when you need it. Here's the thing, no matter who you choose, anyone that you choose is better than foster care. Just keep in mind what foster care looks like for your child. So anyone that you choose is better than foster care. So it's, that's a low bar to get over, but you're going to just start making a list. And don't try to prioritize it. Don't say, well, this is my number 1 choice, my number 2 choice. Just start kind of brainstorming your list. And if you're married, do it with your spouse. Who would we trust? The next thing you're going to do is you're going to start listing your parenting values. Now, notice on the screen it says your top 3 parenting values. I don't want you to sit there and try to figure out what are my top 3 values. What I want you to do is start looking at all of your values when it comes to parenting. Do you want a guardian for your child who has the true potential to love your child? Does religion or spirituality play into your decision? Do you want your child raised in a certain religion or a certain way? Do you want your child, in a nuclear family with a mom and a dad? Do you mind if maybe they're raised by a same-sex couple? Those are the values that you're going to be looking at. Maybe you want your child to never have to move away from where they are. They got great services, they got a great school, they know their neighbors take care of them, and your whole thing is that you don't want your children to have to move if something happens to you. So just start making a list of all of these values and priorities that you have when it comes to parenting your children. The next thing you're going to do is, out of that list, take some time and pick your top 3. Which are the ones, if you had to pick only 3 out of your list that you made, which would you pick? And then look at your list of potential guardians that you created in the first step and start matching up. Do Bill and Jane have these 3 top parenting values that I want? Well, they share one, but maybe not these other 2. So those are going to kind of go down the list a little bit. Oh, but here, Bob and Sue, that'd be a great choice. They have all 3 of these our parenting values. They would raise our child exactly the way we would want. So you start matching them up. And when you do that, you're going to get your short list of 3 to 5 people that you would trust to raise your child the right way. Some of you may be thinking, well, maybe there's, my brother and his wife would make a great choice. So you have to ask the question at that point. So what if your brother and his wife got divorced? Would you want your sister-in-law, your former sister-in-law, to still be able to be a guardian for your child, or would you want it only to be your brother and your sister-in-law as long as they're married? But if they are no longer married, or if your brother dies, then the sister-in-law is out. So you can actually designate how those relationships would work as potential guardians for your children. So once you create that list and you compare it to your values and you come up with your short list, these are now your priority permanent guardians. These are the people that you believe would do the best job of parenting your children with your values. Okay, so now we need to go back and look at, what about short-term guardians? What about that time period when something has happened to me and the court has not yet appointed a long-term guardian, and I don't want my child to be in foster care during, for a couple of hours, days, or weeks while the court figures this out? Who can I name and give legal authority to take care of my children in the short term? Now, it may be somebody on your long-term guardian list, but it may not. And here's the criteria. First of all, and we're going to call these first responders. These are people that you trust. Okay, and again, you're going to look at people like teachers, principals, pastors, priests, neighbors, someone you would trust to really take care of your child and keep them safe, and give them emotional support as well. This person needs to live within 20 minutes of wherever your child is. If your child is at home or if your child is often at school, you want to find somebody within a 20-minute radius, because they need to be able to get to your child within 20 minutes, because if the police have to wait very long for someone to show up with legal authority, they're going to call CPS. So you want somebody who can get there quickly. This also needs to be someone who really cares about your child and can provide comfort to your child. Your child's going to be confused, stressed, and displaced from their home. And if you're talking about a minor child with special needs, it's going to be even more distressful. And it needs to be someone that your child also knows, loves, and trusts. Someone that your child can receive comfort and love from, because they have that relationship with them. And often this is a sibling or an aunt or uncle or grandma and grandpa, somebody like that who can get to your child quickly. So with that information in mind, go ahead and go to page 5 of your workbook. And there's a section there called Guardianship of My Minor Children with Special Needs. And kind of go through there. Now, we probably don't have time to go through the whole exercise right now, but make some notes in there about what you need to do to start thinking about who these guardians should be. Because the reality is that you must provide legal documentation to these first responders to allow them to take custody of your child. Your word is not enough. It's not enough for your neighbor to come over and say, I watch Jimmy all the time, I'll take care of him. That's not acceptable. The state has a duty to ensure the safety of your child, and they are not going to trust a neighbor who claims that they take care of your child all the time. Your neighbor has to have legal documentation to be able to do that. And we actually have a program for that. We call this our Kids Protection Plan. And is specifically designed to give you the proper documentation for these short-term first responders, short-term guardians, as well as your long-term guardians. So moving on to your adult child with special needs. What about guardianship for your adult child with special needs? Now, again, keep in mind, the state looks at any person 18 years old or over as an adult. And as such, that person needs to be able to give consent for medical care. They need to be able to sign a contract to buy a car, whatever it is. If you're 18, under the law, you have those rights. But when you have an adult child with special needs and you know that that child cannot give consent to medical care, does not have the ability to sign a contract, does not have the ability to be self-sufficient or to make personal care decisions or financial decisions, and you're thinking, well, maybe I need to be their guardian. We get this question a lot. People call up our office saying, I think I need to become a guardian for my child, what's involved. And one of the first questions I ask is your child going to be able to live independently or semi-independently? Can they give consent for medical care? Because more often than not, I actually hear, yes, they can give consent for medical care. No, I don't think they should be entering into a contract. I think they would get taken advantage of. And so what we find is that maybe sometimes guardianship of your adult child is not necessary. And there are alternatives that we can suggest. Because in the reality is that guardianship is a court monitored process. You have to go to court, you have to make your case, and the court has to decide if you're going to make a good guardian. And then once you do that, you have to report back to the court every year on your child's health and financial status. And the court has to verify that you're doing your job as the guardian, even though you're the child's parent. Legally now, you've moved over into guardianship, and the court's going to monitor you as long as you're that child's guardian. So there are some alternatives we can look at. One is we can actually do what's called a limited guardianship, in which maybe you ask the court for guardianship over only certain aspects of your child's life. Because if you get normal or full guardianship, your child will remain a minor child in the eyes of the law, throughout that entire time. They'll never be able to vote. They'll never be able to get a driver's license. They'll never be able to make decisions about their own life. And I have, speak with a lot of parents who have children with special needs, and they're doing well. They've graduated from college. They just need some assistance, and absolutely would not want guardianship over them. The other option is just doing a conservatorship. Conservatorship in Arizona is just control over that person's finances. And so maybe they can do everything else. They just can't manage their finances, and they get a paycheck and they lose it, or they gamble it, or they give it away to their friends. And so maybe all we need is someone to be a conservator of their finances. Many of you are probably already representative payees if your child's getting SSI or other public benefits. And sometimes that's all you need. That's enough. And so what we really have to do is take a really close look at your particular situation and figure out what is the least amount of oversight that you can do while protecting your child, but also giving them the liberty to live their life as an adult, even though they have the special needs. Now, if your child is at all capable, if they have the mental capacity, they should absolutely, if they're over 18, complete advanced healthcare directives, giving you or somebody else they trust the authority to make healthcare decisions for them. And they should also consider doing a financial power of attorney so that if something happens to them, you can get access to their assets. If they're working and they have a bank account, you can get into that bank account if you need to. So these are some of the alternatives when we talk about guardianship of our adult children. So this is something that, again, when I meet with clients, we take a really close look at the entire picture, and we work together to find out, again, that least restrictive level of assistance for the adult child. So in your workbook, there's another section called Guardianship of My Adult Child with Special Needs. So if you'll look at that, go ahead and start filling that out as well as we continue on, or at least make some notes in there about things that you need to do when you come back and look at your workbook later. So now let's move on to critical step number 2. So the first one was making sure that our children stay out of the hands of strangers and that we have proper guardianship in place. The second one is providing enough financial resources. And this is where a lot of families really struggle. We have quite a few families come in and they're doing fine. We have many families come in and they're really worried about their children with special needs, and they just are barely getting by themselves month to month, have very little savings or other resources. So this is the harsh reality. And that is providing financial resources for your child with special needs is ultimately your responsibility. We can't escape that. I am responsible for Anthony's financial support. He cannot support himself. Public assistance is not sufficient to support him. What is it, like $763 a month or something like that? I don't remember exactly what it is right now. That's supposed to get housing and food. It's not going to happen. And so I have a responsibility to Anthony to make sure that for the rest of his life, he is taken care of financially. And that's a heavy burden for a lot of parents of children with special needs to carry. So one of the first things you need to do, though, is to figure out what's it truly going to cost for my child to be housed, fed, and cared for at a minimum throughout the rest of their life span. And we call that a life care plan. And that's one of the first steps you should take, is get a life care plan. And you can go to, there are some websites, I believe, if you Google it, you'll find a couple of different tools online that you can use to do that yourself. Or if you go to a life insurance provider, they often have tools and they'll help you work you through doing a life care plan so that you can consider the appropriate amount of life insurance. The other question is, looking at a special needs financial plan and life insurance. Now, this is really, I'm not a huge proponent of life insurance. I think that it's very appropriate for a lot of people. But when you have a child with special needs and you don't have other resources, I think life insurance is the #1 asset that you can provide. And I know I hear people say all the time, well, I'm not insurable. I'm too old. I have a prior medical condition. I can't afford it because of because I'm too old or have this medical condition. And I just want to let you know, we work with a team of life insurance agents and financial planners And they work exclusively with parents of children with special needs to make sure they get into some kind of financial plan and life insurance. And there's just it's an amazing group of people. And I just want to let you know, we can usually figure something out so that when you die, you're able to ensure that your child has some kind of financial security when you're no longer there to provide for them. This would be a great time to go to page 6 of your workbook under action items. And it says, which of the following statements describe my current financial resources? So kind of take a look at that, compare it to what we just talked about, and then list some things that you might want to do to improve your financial position if you do not have enough resources. All right, let's go to the third critical step. The third step is your own plan. And I absolutely recommend that if you do not want to have your family go through that probate process that we spent some time talking about this morning, you can absolutely avoid it. And you can avoid it by simply preparing what we call a revocable living trust. And you know, it used to be that we considered trust only for the wealthy. And that has changed over the past 10, 20 years, where now everybody's getting a trust, and it doesn't matter how much money you have. And you might hear people say, well, if your estate's worth less than $500,000, you shouldn't get a trust. That's just absolutely not true. The decision to create a trust is really based on whether you're okay with your family going through probate when you die, or if you would like for them to not have to go through probate when they die. That's the bottom line. So this is, again, the only foolproof way to avoid probate is to create a revocable living trust and have it fully funded with your assets. And let's do a quick comparison. But how is a trust different from a will? First of all, a will must go through probate. With a trust, your assets pass to your beneficiaries outside of probate, never have to go to court. A will is time consuming. We already heard it's going to take 9 to 12 months at least to get through the probate process. With a trust, your assets are transferred immediately to your beneficiaries, or at the time you choose. If you don't want your 18-year-old getting your assets, in a trust, you can say, well, no, I don't want to get them until they're 25 or 30. You can't do that really with a will. With a will, there is a significant cost at the time of probate. Whereas with a trust, it's a very minimal cost because there is no probate. There's a small legal fee to prepare an affidavit. A will is public. A trust is completely private. No one ever has to know who received what out of your assets. They never have to know how many assets you had, nothing. Whereas on a will, all that is public knowledge. With a will, your assets pass to your beneficiaries at age 18. With a trust, they pass to your beneficiaries at an age you determine. With a will, your assets pass to your beneficiaries without any protection against bankruptcy, divorce, lawsuits, and judgments. Whereas with a trust, you can actually set that inheritance up where your child doesn't have to worry about ever losing that inheritance to divorce or bankruptcy or a lawsuit. So that's the difference between a will and a trust. And if you're at all worried about your family having to go through probate, trust is a very cost-effective and great way to ensure that they don't have to do so. And honestly, your family will absolutely thank you when you pass, that you've made it so easy for them. So we also talk about here about related documents. What are the other related documents that you should have? You should have a power of attorney. It's called a durable power of attorney. It gives the people that you determine, that you appoint, the authority to manage your financial affairs if you become incapacitated. Otherwise, if you don't have that, you're going to have family members having to go to court and petition the court for the authority to manage your financial affairs, to petition the court to become a conservator of your finances. And they're easily going to pay $2,000 to have an attorney and court fees and everything else to go do that. The other thing, and it may not be the person that you would want managing your financial affairs. So with the power of attorney, you get to say, this is my first choice on who's going to manage my affairs. If that person's not available, this is my second choice. The other documents you're going to need are advanced healthcare directives. These is your living will, your healthcare power of attorney, mental health power of attorney, your dementia living will, and all of these, you're naming the people that will make medical healthcare decisions for you. And you're telling them what kind of decisions you want made. And this is so important. If you have a child with special needs and you become incapacitated, you need somebody in there who's helping make those decisions for you so that your child with special needs is not carrying any of that burden, especially again, if they're high functioning or middle functioning and they feel that burden. If you have somebody you've chosen to come in and make those decisions and communicate with your family, communicate with your child with special needs, it's just going to make it much easier for everybody. If you have minor children, the other document you're going to need is that kids protection plan that names your temporary and your long-term guardians. And obviously you need all of your guardianship paper work and documents, not only for those minors, but also for your adult children with special needs. So now what we've been talking about is what would happen in the event of your incapacity and what would happen if you developed a terminal illness, a coma, or a vegetative state. The power of attorney, the durable power of attorney, is really about your incapacity and planning for your financial wellness. Your plan for terminal illness, coma, or vegetative state, that's where we get into your healthcare directives. So if you go to page 8, you'll see those sections in your workbook. Go ahead and answer the questions in your workbook so that you get a true picture of where you are today in that planning. This is a sample overview of a trust. And I don't want to take too much time here. I just want to kind of show how it works. You can see above the dotted line, that's when the person who creates the trust is still alive. Under the bottom line, under the dotted line, that person has died. And what you see as you move about halfway down is that in this sample, the person who has set up this trust said that when I die, I would like half of my assets to go to my child with special needs, but I want it to go to my child in a special needs trust. And then I would like the other half to go to my neurotypical child, and I would like that in an asset protection trust so that it cannot be taken away by divorce, bankruptcy, or lawsuit. That's how a trust works. It's just an amazingly simple and effective tool to get your assets to your children timely and in a way that protects them and protects those assets. So speaking of special needs trust and that example, that's your step number 4. Prepare a special needs trust. Now, here are some things to think about. If you want to manage your child's resources while maintaining eligibility for government benefits, special needs trust is a perfect tool for that. You can be the trustee of the trust, meaning that you have control over those assets. And you can have as many assets as you want in a special needs trust. You can have $10 million, you can have $10. Doesn't matter. The Social Security Administration does not look at that. What they look at is the trust created properly? And as a trustee, you use those assets within that trust to care for your child with special needs. If you become incapacitated or you die, you've already named people who will step up in your place and continue managing that trust for your child. So your child never loses the benefit of having those assets available to them to help them with their healthcare needs and their clothing and travel and education and things like that. And they are able to maintain eligibility for government benefits because a special needs trust does not count as an asset. It does not count towards that $2,000 limit. There are several different types of special needs trusts though, and when you do your planning, you need to understand what they are because these can get you into a lot of trouble if you don't do it correctly. The first is a self-settled special needs trust. We often call this a first party special needs trust. This trust is specifically for a disabled or special needs individual who has their own money. We often see this with a vehicle accident victim who gets $200,000 in a judgment for negligence of the other driver, and now they're going to lose their benefits. So they can take that $200,000 and create their own special needs trust with that money so that they can preserve their benefits. Here's the little kicker though. If they die, just like with the ABLE account, Medicaid is the first creditor, and Medicaid can take everything in that special needs trust to pay them back for anything they've spent caring for the beneficiary. A pooled special needs trust is a great tool, especially for parents who don't have a lot of resources but want the benefit of the investment opportunity that people with larger resources have. A pooled special needs trust is managed by a nonprofit organization approved by the state. And what they do is, let's say you've got $25,000 that you want to go towards your child. You put it into a pool, and this nonprofit organization, they may be managing 50 or 100 or 300 special needs trusts. So all of that money goes together, and then they invest it so that it grows. And your child's special needs trust gets the benefit proportionally for how much you put in. Again, if your child dies, Medicaid is going to get their payback first, and then typically if there's anything left over, it goes to the nonprofit to support the nonprofit. So if you have any idea of saying, well, if my child with special needs dies, I would like for anything left over to go to my other children, the self-settled trust and the pooled trust are probably not going to get you there. So that leaves a third option. That's called a third-party special needs trust. And a third-party special needs trust is created by typically a parent or a guardian or a friend for the benefit of the person with special needs. This trust can be created now while the creator is alive, or it can be created at the death of the parent. Either way is fine. The great thing about the third-party special needs trust is there's absolutely no payback. So let's say that you qualified for $500,000 in life insurance, you die, and you've named the third-party special needs trust as the beneficiary. So $500,000 goes into your third-party special needs trust. 10 years later, your child with special needs dies, and there's still $200,000 left in their trust. Medicaid can't touch it, and you get to say within that trust if you want that $200,000 to go to a charity, if you want that $200,000 to go to your other children, or who you want it to go to. So a lot of flexibility with a third-party special needs trust, and it absolutely protects your child's eligibility for benefits, and Medicaid cannot get their hands on it. So that's the most common type that we create for people. It's just really a great tool to ensure that your children or your child with special needs has the resources they need. So here's the bottom line. You must use the right kind of special needs trust. That means you need to speak with an attorney who understands these different types of trust, because what often happens is you get the wrong kind of trust, or if it's not worded correctly, Social Security Administration will reject it, and suddenly they're counting whatever resources are in that trust as an asset for your child. And so the Social Security Administration, they're pretty strict. You guys probably know that. So you have to choose the right special needs trust, and it has to be drafted correctly. Now, here's some of the benefits of creating a special needs trust. All those assets that you place in a special needs trust are protected. So let's say you have a high functioning child who gets married and then gets divorced. Their new ex-spouse cannot get their hands on that special needs trust assets. Let's say your adult child does something negligent and gets sued, and the court says, that your child needs to pay the victim $50,000 for damages. The court cannot go to that special needs trust and say, well, you've got money in there, you can pay it out of that. It's not touchable by the court. And you've got this constant benefit of being able to have those assets in a protected trust and maintain government eligibility for your child. So a great tool. So let's move on down to the last critical step. Again, we're talking about making sure that you're doing proper planning for the care of your child with special needs. And we've talked about guardianship, temporary and permanent and long-term. We talked about guardianship of adults. We've talked about making sure that you have sufficient resources, most typically through buying life insurance policy and doing creative financial planning with people who understand where you're coming from. We talked about doing your own estate planning and creating all those documents that you need so that your family and your child with special needs are not burdened with that, and that you can get those assets to your family and to your child in a way that actually helps them rather than hurts them. And then just before this, we also talked about the benefit of creating a special needs trust for your child with special needs. So this last step is getting away from the talk of money and insurance and all of that. And now we're going to talk about passing on more than your money. So I think at the end of the day, what truly matters is your legacy. Now, I'm not saying that you don't need legal documents. You absolutely need the proper legal documents in place. You need a well-crafted special needs trust. You need a well-crafted revocable living trust. You need well-crafted healthcare documents and power of attorney. Absolutely. But those are just the documents. Ultimately, what will your family really appreciate when you're gone? They're going to appreciate that you did the planning, but that's going to last for a while. But what is something that they will remember you for forever? And I'm just going to go through here and take a look at some things. You have so much to offer your children when you look at all of your intellectual and spiritual values. I think most of this is true for all parents. We try to pass on to our children our human, intellectual, and spiritual values. And while I'm talking about this, you can go to page 10 in your workbook. It says pass on more than just your money, and you can start jotting down some ideas for yourself. So, what do you think your loved ones care about most? Do you think they care about your money, or do they think they care about your memories and the lessons that you've taught them throughout their life? And I tell this story about my dad. My dad died 20 some odd years ago. And before he died, he told me, John, I have my big regret in life is I wasn't able to leave you an inheritance. And it just kind of broke my heart. And it's like, Dad, you have left me such a huge inheritance because you have taught me so much about life. You know, your legacy to me is your compassion for other people, your passion for what you do, your ability to use your hands to roof a house, to build an addition to a house, to be a plumber, an electrician, you know, all these things that you've taught me throughout all my life, how to stand up in front of people and speak and to teach. You know, these are all things I got from my dad. I told my dad, that's what you've left me. That's what's so much more valuable than any kind of money you could ever have left me. And I believe that's true for most people. You know, once you die, you know, your family isn't going to take your will or your trust and set it on the nightstand so they can remember you. They're going to look for other things, photographs and videos and recordings and other things that you've done. That's how they're going to remember you. So what are your most cherished memories? And you know, I also look at this like, what are your children's most cherished memories? How can you capture those for your children and pass those on so that they remember you in that context? How can you make sure that when you're no longer with them, your children remember how much you loved them and they know that you loved them? And specifically for this audience, passing on those instructions for the care of your child with special needs. I kind of think of it as, you know, the manual, if you will, for our children with special needs. I can tell you right now that if someone takes care of Anthony, the first thing they need to know is never give Anthony even a drop of artificial sweetener. He is highly reactive to it. His bowels will rebel, and everyone will pay the price for at least a week. And he'll be embarrassed and he'll be upset, and it's not really fun for him or for anyone else. I can also tell you that when Anthony gets overstimulated, he's going to go into the bathroom, he's going to run a tub of hot water, and he's going to sit there sometimes as long as 2 hours, because that's how he's able to calm down and soothe himself. You know, anyone taking care of Anthony needs to know that he has a nose for sugar, better than a bloodhound. He can find Oreo cookies in the top shelf of the pantry, hiding behind the pasta in the middle of the night like nobody else. And he'll deny it to his dying breath that he ever ate them, even though he's got, you know, Oreo chocolate all over his lips and teeth. So, you know, those are just small examples. Anthony only sleeps about 3 or 4 hours a night, and then he takes a nap in the afternoon for an hour or so. That's how he has lived for 30 years. Nothing we've ever done has been able to change that. So he needs to be okay for Anthony to stay up and play video games until 2 or 3 o'clock in the morning. If you take that away, he's just going to become frustrated and upset, and he's not going to understand why. He's going to cry, he's going to become angry, and he's not going to sleep at all. And, you know, we just have to, people have to understand that that's just how Anthony is, and that's how it works for him. No one would ever know that if we didn't write it down and have that as part of our plan for Anthony, so that if his mother and I are not available, whoever takes care of him can have a manual to understand how Anthony works. So kind of the big question, you know, I guess what it all comes down to is, how will your children remember you? You know, as a person, as a parent, as a wife, husband, son, daughter, brother, sister, aunt, uncle, whomever, I believe what really matters most at the end of the day is your legacy. And whether you really know it or not, you have a legacy right now. It may not be the legacy you want, but you have a legacy and you can always change it. And so when I talk to families about this, one of the questions I ask is, what do you value most about your life up to this point? And most people can point back and say, you know, and I'll give an example. My 20 years as a flight paramedic, I learned so much and I had such great experiences. Got to travel all over the United States, Canada, Mexico, Belize. You know, it was a great era in my life, and that's what I really value. And I have other things I value. So that's one of the things that comes to mind. And then I asked them, okay, so if that's where you are today, if time or money were not an issue, what would your future look like? What would it look like for you? And what would it look like for your family after you're gone? And we don't have time to go into all this today and kind of explore this, but one of the ways that once we've answered these questions and we've kind of nailed down, you know, what parents are really looking for, you know, besides just an estate plan today, but how can they create something for the future? Is we work with them to write letters, to record a video, to interview them on video or on audio, to have meaningful conversations with their family, to heal families, and to create memories. So the important thing is it doesn't matter which method you choose or where you end up. The important thing is that you actually sit down and do it. And, you know, as an attorney, you know, drafting legal documents is only one aspect of what I do. And I don't think I'm not serving you well if I don't help you begin to even think about and touch upon the fact that you have a legacy, and we can capture that legacy within your estate plan, within your letters, within these recordings, and within these conversations with your family about your planning that you're doing and the future that you want. So, you know, I kind of see that as part of my purpose in life. Right after helping families like yourselves put together estate plans to serve their children with special needs, is helping families see their purpose in life and to see their legacy and help to capture that and plan for it. Just a quick guide, you know, it's like, well, what would be your legacy? How do you even start thinking about it? And so one of the things we look at are financial. Do you have a business, a family foundation? Maybe you want to start a family foundation because you have some values that you want to put out there that will last through the generations. Your estate plan, your special needs trust, all of these things are part of your financial legacy. The other part is intellectual. What knowledge or skills have you passed on to your children, or will you pass on to your children? What are your intellectual assets? And you know, this is one that really kind of snuck up on me, and I wish I had known this when I was much younger. But from a social perspective, how are you preparing your children for adulthood through exposing them to your network of business associates, of friends, of your social structure, your social circle? Because as your children grow up and become adults and they need references for college, or they need you know, to help finding a job or a career, your social network is going to be a safety net for your child. And the more you can expose them to that and expose your network to your children, you know, they're going to watch your children grow up and they're going to say, oh, hey, you're John's kid. You know, sure, I'll be happy to write you a referral for college. And then on the human side, what are the stories that your family values? And, you know, our family, you know, every time we got together for a holiday, my dad would tell all these stories growing up about his brothers and his mother and you know, all these funny stories that we thrived on, we lived on those. And my dad's not here to tell those stories anymore. I don't have them recorded and I miss them. I wish I could go back and listen to my dad tell them again. My dad, you know, was just a very wise and compassionate person, and I could always go to my dad for advice. And so, you know, how can you capture those stories and your wisdom and your life experiences so that your family and your community of loved ones can continue experiencing them even after you're gone? And finally, looking at your spiritual assets. I'm not talking about religion here. I'm really talking about looking at your life from a spiritual perspective of how do you guide your family to function from a level of the spirit of giving and loving rather than from hate and greed? And how can you capture that for your family? All right, so that's pretty much it. Let's do a quick review. 5 critical steps. Choose the right guardians for your child, whether they're a minor or an adult. You need to provide enough financial resources for your child. You need to prepare a revocable living trust and all the related documents if you at all do not want your family to have to go through probate when you die. And it's fine if you say, you know what, I don't care if my family goes through probate. I'm not going to be here. That's fine with me. Then absolutely, we can set you up with a will and your family can go through probate. But if that bothers you and you don't want that for your family, then we can easily address that with a revocable living trust. For your child with special needs trust is the #1 way that you're going to protect their assets, maintain their eligibility for benefits, and ensure that they have something for the future to help supplement their benefit payments through SSI and SSDI and things like that. And finally, pass on more than just your money. Recognize all the other assets that you have besides money that you can give to your children. So what I'd like for you to do right now, page 11 of your workbook, titled My Truth, and select the answer there that most speaks to you. What is your truth? After hearing this information, what is true for you? And then right underneath there is a place for you to make a commitment. And this commitment is not to me. This is a commitment to yourself. It's an agreement with yourself that you are going to do whatever you have to do to ensure that you've done the right thing, to plan for your child the right way, and to make sure that all of these things are in place for your child. And I want you to sign that. Again, this is not for me, it's for you, but signing it will indicate to yourself that you're making a commitment to get this stuff done for your child. So now I just kind of want to invite you to remember why you're here. This is my family. When we first started, I had you look at in your workbook. The very first thing I asked you to do was to write down who would be impacted and how if you were no longer here. And if you did that, I want you to turn back to that page and look at those names you wrote down there and double check them and think about it. That's why you're here, listening to me on a Wednesday night. Those are the people that need your protection. My children need my protection. My grandchildren need my protection. They rely on me for that. And they need me to put the legal documentation in place to ensure that protection. But more than that, they need my legacy. They need to know what it's like to be loved. They need to know what it's like to learn compassion and to share and to love and to be generous. And that's part of the legacy that I get to pass on to my children, even if I don't have assets to pass on to them and make them rich when I die, which no one's going to get rich when I die. I can assure you of that. Anthony will be taken care of, and that's really the bottom line for me. Everybody else understands that, and they're good with that. So the good news is that I've given you a lot of information, but you really don't have to do this alone. There is help, and you have 2 options here. One is you can do this all yourself. You can go back, you can listen to this again, you can figure out how to get your will done and get your guardians named, and you can follow that same rocky path that I followed when I first started this presentation, and I showed you that rocky path with all the fog and the turns in it. You can do that. I did it, you can do it. but it's not easy. You can go online and you can try to, create your own will or whatever. Understand that a lot of the things we talked about today are not addressed in an online estate plan. And you may need somebody to help give you guidance. And so that's your other option, is to work with an attorney. And, attorneys such as myself or somebody else who's really in tune with working with the special needs community, who can give you a tailored and personalized plan. And, for me, for example, we sit down together, I listen to your story, I ask a lot of questions, I incorporate everything I can learn about you and what you want for your family into your plan. And I make it, totally comprehensive and personalized to you. So, some of you may have had experience working with attorneys in the past, and the traditional experience is that you're billed hourly. You don't know what it's going to cost at the end of the day. You can call the attorney's office for 1 minute, and because they bill in segmented increments of the hour, you talk for 1 minute and you're billed for 6 or you're billed for 15. And, that doesn't seem fair or right to me. The other thing is that, often when you work with an attorney, attorneys are trained to spot issues and to provide solutions. And so often what happens is, okay, someone's died, I need to go talk to an attorney and figure out what I need to do as a result of this person dying, or whatever the situation may be. And so in the end, they give you a couple of options, you agree, and they try to fix whatever's happened. And at the end of the day, you really, for the law firm, a transaction, a number. Your matter starts, your matter ends, and then you're done and you say goodbye, and you never really talk to that attorney again unless you have another legal crisis. I feel that that is not a great way to serve clients. And so what I've done is kind of flip this whole traditional experience on its head. And so everything I do is flat fee. We agree to that fee in advance. You don't have to worry about every little call or email because we don't keep track of our time at all. You can have a million questions about your plan. I guarantee you, I've had clients who call every day, sometimes several times a day, because they have questions. But we're here to answer those questions and to help you make sure that your plan is exactly how you want it in the end. Plus, I love interacting with my clients at the estate planning level. I enjoy learning about my clients. I enjoy being able to address those issues in advance and create plans and put these plans in place that will prevent the crises that lead them to attorneys and lead to those reactive kind of responses. So it's all about really deciding ahead of time that you want to avoid that and get that planning in place. And part of that for me is understanding that your relationship with the attorney should actually be a relationship, not based on a transaction. And so what we strive to do is we stay in touch with our clients over time, because the reality is that your estate plan needs are going to change. You don't do an estate plan one time, put it away, and it's good forever. Every few years, we get changes in the law, or your life will change. Your child with special needs will become an adult, maybe move out of the house, maybe move into an assisted living, or maybe they'll stay with you. You might get divorced or remarried or start a business or sell your house. All of these things can affect your estate plan. And so we're here to try to work with you on an ongoing basis and make sure that your estate plan isn't good just for today, but that it's good forever. That as changes come about, we're staying in touch and we're adjusting things so that when your family needs it, your estate plan actually works for them. So here's our promise to you. When you work with us, our promise to you is that your estate plan leaves no stone unturned, and will give you peace of mind that your loved ones and assets are kept out of court and out of conflict. How do we do that? What's the process? Well, we actually use a 3-meeting process, at least, sometimes more. But the initial meeting is called your Special Needs Life and Legacy Planning Session. And that's where we sit down one-on-one together. And in advance of that session, you're going to complete some online homework. It's called your Special Needs Life and Legacy Assessment. And we give that to you in an easy and secure way so that your information stays private. And you give us information about you, your family, your children, your assets, your values, all this information we've been talking about. And in advance of our meeting, I go through all that information so I can prepare to really give you the best counsel and advice. Once we're in the planning session, we hit the ground running. I'll ask you questions, you'll ask me questions, and we'll really get to know each other and nail down all this information. And then together, because you've been educated and empowered and informed, you're going to make the decision about what's the best plan for you and for your family. And then we can start designing that plan right away, that same day. And once we have that done, then we sit down, you sign the engagement agreement, and you pay the flat fee. You only have to pay half of it at the first meeting. You don't pay the whole thing. About 4 weeks later, we get together and we sign all your documents. And a lot of stuff happens in that 4 weeks. I'm not going to go into all of that, but there's a lot of information and communication going on during that 4-week period. But at the 4-week point, you come back in and we sit down and we sign all of your documents. And at that point, your plan is actually legally in place. It's a big day. That's the day where the weight lifts off your shoulders. And that's the day to actually, bring some champagne to the office and we do a toast, we celebrate because, everything that you've expressed as your wishes and your desires has been put down into legal documents, and that's what's going to happen for you. Typically at the signing ceremony, we ask you to pay the balance of your fee. Sometimes that's not possible, and we work really hard to make arrangements to make sure that we make this possible for everybody. The last thing that happens, we meet about a month later, and we give you all of your documents. Again, there's a lot of stuff going on in this next 4-week period, but we really, at that time, we sit down and we talk to you about your plan, about keeping your plan current as your family grows and changes. And so we kind of go through all of that with you again and show you, how we work with you to make sure that your plan is always current. In that final meeting also, often what we'll do is we'll actually do like a video or audio recorded interview. So we can begin capturing that legacy that you want to leave for your family. And ultimately, when you leave, you're leaving with peace of mind that you've done everything you can to make sure that your family is protected, cared for, that your child with special needs is going to be eligible for benefits while still having resources and assets to keep them from living in abject poverty, and make sure their needs are met, and you're taking home that peace of mind at the end of the day. So I really I want to thank everybody for this opportunity to be with you. As I promised you at the beginning, we do have a bonus for you. You guys have stayed with me. I think we've lost one person over the past 2 hours. You guys have stayed with me. That's great. I appreciate it. But the first thing we're going to do is we're going to give you a gift. It's $750. And what that covers is that 2-hour meeting with me, access to my online calendar. And you get a 2-hour meeting, and we're going to waive the $750 fee that I normally charge for that 2-hour meeting. If you sign up for the next 24 hours to meet with me, we're going to take $250 off of any trust plan or special needs trust that you create. And so that's just to kind of give you a little motivation to not think about it too long. If you know you want to meet with me, this stuff really resonates with you, and you think you want to do some planning, you sign up within the next 24 hours, and we'll give you an extra $250. So I'm going to ask Patricia to go ahead and put that link up into the question or the chat box. And so this is what's going to give you access to my online scheduler. Now, I don't give this out to everybody. Not everybody, can just go in and get on my schedule. But you guys have stuck with me, and you've been just a great audience, and I'm just really appreciative. And I want to give you access to my scheduler to get on there. And again, when you go to the scheduler, there's a form you have to fill out. At the bottom of that form is a promo code. And if you'll put in that promo code 5 steps, that's all you have to do, 5 steps for the promo code, we'll make sure that you get your $750 fee waived for that meeting with me. And if you do it within the next 24 hours, then we'll add another $250 off towards a special needs trust. So it's HiltonLawPLC.com/schedule online. That's the website to get to my scheduler. HiltonLawPLC.com/schedule online. Be sure and put the promo code 5 steps so we can be sure to give you all these, this is $1,000 worth of services that we're giving to you at the end of this. So what do you need to do? Schedule it, and then show up, design your plan, and leave with that peace of mind that all of our clients tell us, when they leave, I didn't realize how much burden I was carrying, and having done this, I have so much peace, and the burden's been lifted. And so that's what you got to do. Show up, be ready to work, design your plan, and then leave with that peace of mind. All right, so again, thank you guys for attending, and I believe we do have time for a few questions. We're right at 2 hours, but if anybody has any questions, hopefully you've placed them into the question box on your taskbar. And so, Patricia, do you have anything?
Yeah, John.
Yeah.
Yeah, we do have quite a few questions, but we're kind of running short on time. So I kind of grabbed those that are particular to special needs.
Okay.
For anybody who doesn't get your questions answered here live, we will be sure to answer them separately. But first, can I still preserve my child's eligibility for benefits if I don't establish a special needs trust?
Yes, you can. That's a great question. The other vehicle for preserving your child's eligibility is that ABLE account. So really those are the 2 big options that you have if you want to make sure your child has access to assets for their care, but you want to preserve their benefits. What I believe is the best choice is the special needs trust, because anything placed in that, Medicaid can never get to it, and it's always there for your child, and it can never be touched by a court or by divorce, anything like that. The ABLE account is also an account set up to preserve your child's eligibility. The only thing you have to remember is that if your child dies, Medicaid will be the first creditor, and they can empty out anything that's left in that account.
How do I know if my adult child with developmental disabilities needs a guardian?
That's a difficult question. And that's really one that I think I'm going to not try to address specifically, because what we really need to do is sit down and really discuss your child's capabilities and functional ability, and work together to figure out just how much control is necessary in your child's life while still allowing them to have some independence as an adult. So it's really difficult to answer that question with a blanket statement.
Yeah, having independence is very important. How do I calculate how much money my disabled child will need throughout their lifetime?
Yeah, so you know, I'm sorry, I cannot remember the website right now, but if you Google it, Google Life Care Plan, Life Care Plan, you'll find some tools online that will help you figure out how much you need. It's all based on your child's diagnosis, their age. You know, the tool helps you figure out your child's projected lifespan, what their needs are going to be, what their medical needs are going to be, and you can get a figure there for you know, an estimate of what it's going to take. They factor in inflation and all of that to figure out how much total you're going to need to care for your child. It's a fairly time-consuming and deep process, and I really recommend that you get a hold of a qualified life insurance provider who can take you through that and help you answer those questions, so that you're not just on your own trying to get through it.
So John, if we set up my child's ABLE account, can I transfer my house into that ABLE account?
It's actually a common question, and unfortunately the answer is no. The ABLE account can only hold cash assets. It's just really like a bank account. If you want to provide a house or living arrangements for your child, you'd really need to consider a special needs trust, because a special needs trust can hold any kind of asset. It can own cars, houses, cash, stocks, bonds, investments. It doesn't matter what type of asset it is. A special needs trust can own that, but an ABLE account is cash only.
Can I set up my estate to make sure my child with special needs can always live in my house even after I've died?
All right, yeah, it's a great question, following up on the one we just answered. Yes, there are absolutely ways to do that. A lot of it depends on various conditions. You know, are you still paying a mortgage on your house? You know, there are a lot of questions that we have to really get into to figure out the best way to do that. But yes, that's definitely a possibility where you can set it up so that your child with special needs always has a home and has the home that they grew up in or are comfortable in, and you don't have to worry about them being displaced and placed in an institution or out on the streets.
So I'm going to jump over to one kind of general estate plan question. There were a couple, and they all kind of fall into this area of, I have a family member, I don't want to be a guardian of my child. What do I do?
Yeah, that one, you know, is unfortunately a common question, and you know, it's something that we do often encounter, and we have to work with our clients on. But just as we talked about in the guardianship things, where you want to figure out who your guardians will be. You know, who do you want to be your guardian? Who do you want to be temporary guardian? Sometimes clients say, but there are people in my life that I know if something happened to me, they would be right there at the court. They'd be the first ones petitioning for guardianship, and I don't want them to ever raise my child. You know, they don't have any business raising a child with special needs, or even raising any child. And usually, you know, maybe they have different values than you. Maybe they're a felon. You know, all kinds of things that come up. But it doesn't matter why you don't want that person to raise your child. When we do our planning for guardianship for minors, or kids protection plan, one of the things that we go into is figuring out if there are people that you absolutely would never want raising your child. And we can actually create what we call an exclusion letter, which we lay out and you sign it, and it says, I would never want this person to raise my child, and these are the reasons why. You sign that, we put it in a sealed envelope. And if that person ever has the opportunity to come forward to the court and say, I want to be the guardian of, my sister's child or whoever it is, then that letter is presented to the court. They can look at it in the privacy of their chambers, and they can know that this person should not be considered as a guardian because there are things about them that the parent does not agree with or does not feel is appropriate to be raising their child.
Okay. John, it's about 10 after 8. I think we should be respectful of everybody's time.
I agree.
So maybe we'll just wrap it up here.
Sounds great. Again, thank you, everybody. One last look at my beautiful son, Anthony. The reason I'm here educating you guys, because I know each of you have similar pictures of your children that are so valuable and cherished by you, and you want to do what's right for them. So thank you again. And remember, go to that website, hiltonlawplc.com/, schedule online. If you want to take advantage of this $1,000 gift that we're giving you, $750 towards a 2-hour meeting with me, $250 off of a trust plan. If you want to do that, do it now. Within the next 24 hours, you're still eligible to get that extra $250 off. Thank you and good night.
Good night.